Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. There have been a couple of voting rights cases that have come out in the past month, and I've been meaning to get to these, and I haven't as of today, so today I'm going to take on the first one, which is out of the Fifth United States Circuit Court of Appeals, and it deals with a law that Mississippi has regarding felons. And specifically, the Mississippi law regarding felons says a felon has a lifetime ban on voting in state and federal elections. And as a result of that, anybody who has committed a felony in Mississippi can't vote there any longer ever again. There has been a lot of talk in recent years about this being a violation of the Eighth Amendment. And of course, many states, including Florida, have gone on to impose a period of disenfranchisement only for the period of time that somebody is serving their active sentence in any term of probation, which I think probably comports better with notions of justice. Mississippi, however, has things differently. Let's take a look at how the Fifth Circuit Court of Appeals dealt with this issue. So this is Hopkins et al. Against the Secretary of State in his official capacity. In this case, the decision had already been written by the Fifth Circuit, and the petitioners here, the people who were appealing, asked the en banc court to convene in order to reconsider a panel decision. So what does it mean when the court sits en banc? Well, the Fifth Circuit, who heard this case, has 17 judges. And if you got all 17 judges together to hear every case, it would take quite a long while. So most courts use 3-judge panels. And when a 3-judge panel gets it wrong, or when the majority of the court thinks the 3-judge panel got it wrong, they can vote to rehear the case en banc. And that's what happened here. The district court here upheld the constitutionality of Section 241, which is the constitutional provision that's at issue. The 3-judge panel overturned that ruling. The state petitioned for en banc rehearing, and the court granted it. And now they are issuing their opinion in that regard. So here we have the en banc court convened to reconsider a panel decision holding Section 241 of the Mississippi Constitution, which disenfranchises those convicted of certain felony offenses, fails the test of the Eighth Amendment, as incorporated by the 14th Amendment's Due Process Clause. We reject that result because the United States Constitution cannot properly be so interpreted. The Supreme Court in Richardson v. Ramirez reaffirmed the body of constitutional law expressly permitting states to enact felon disenfranchisement. And even if modern jurisprudence under the Eighth Amendment is applicable, which it is not, the case law cannot be stretched to outlaw Section 241. So Mississippi, like all states, imposes restrictions, and this is Section 241 of the Mississippi Constitution. Every inhabitant of this state, except idiots and insane persons, which are expressly not defined in the Constitution, who is a citizen of the United States of America, 18 years and older and upward, who has been a resident of this state for 1 year, and for 1 year in the county in which he offers to vote, and for 6 months in the election precinct or in the incorporated city or town in which he offers to vote, and who is duly registered as provided in this article, and who has never been convicted of murder, rape, bribery, theft, arson, obtaining money or goods under false pretense, perjury, forgery, embezzlement, or bigamy, is declared to be a qualified elector, except that he shall be qualified to vote for President and Vice President of the United States if he meets the requirements established by Congress, therefore, and is otherwise a qualified elector. Mississippi disenfranchises these felons for life, though voting rights may be restored by a 2/3 vote of the state legislature under Section 253 of the Mississippi Constitution. So they close the door and they provide a very tiny keyhole. Laws like Mississippi Section 241 have faced many unsuccessful constitutional challenges. When the Supreme Court ruled that the Equal Protection Clause does not bar states from permanently disenfranchising felons, it dispensed some advice to the losing parties. We would by no means discount these arguments if addressed to the legislative forum, which may properly weigh and balance them, but it is not for us to choose one set of values over the other. If respondents are correct and the view which they advocate is indeed the more enlightened and sensible one, presumably the people will ultimately come around to that view. And if they do not do so, their failure is some evidence, at least, of the fact that there are two sides to the argument, which is the Richardson versus Ramirez case. In other words, go to the state legislatures, do the hard work. The paramount lesson of the Constitution in Richardson is that changes sought by plaintiffs here must be achieved through public consensus effectuated in the legislative process and not by judicial fiat. And this is what lawyers mean when they say that a judge doesn't legislate from the bench. Essentially, matters of public policy should be left to the legislature because they are accountable to the people. Judges who are appointed for life tenure, either in the federal district court or in the United States Circuit Courts of Appeal, are not beholden to the people. They are appointed for life. They can't be removed unless they engage in bad behavior. Essentially, that means in most cases being impeached. And so, for that reason, it is a good thing when judges use restraint and discretion when interpreting constitutional provisions of this kind in the Mississippi Constitution. So, these judges recognize that the state is, under the federalism system, it has the right to do this. And as a result, they're not going to step over the legislature in Mississippi in order to enact a policy change. So the case goes back to 2018. 6 Mississippi citizens who've been permanently disenfranchised pursuant to Section 241 claimed that it inflicts cruel and unusual punishment of permanent disenfranchisement while it also violates the Equal Protection Clause by impermissibly burdening their right to vote. The parties filed cross motions for summary judgment. The district court rejected the Secretary's argument that plaintiffs lacked Article III standing and that ex parte young equitable relief is unavailable. On the merits, however, the district court upheld Section 241 and certified its order for interlocutory appeal. The appeal was decided by the panel adversely to the Secretary to the extent that the panel declared Section 241 to violate the Eighth Amendment. This court vacated the panel opinion for en banc rehearing. Before this en banc court, the plaintiffs contend that Section 241 violates Eighth Amendment as cruel and unusual punishment, and it's not saved by the 14th Amendment's proviso that states may disenfranchise a citizen convicted of other crimes. To succeed in these positions, the plaintiffs must overcome the formidable obstacle of the Supreme Court's decision in Richardson versus Ramirez. The following analysis responds to plaintiff's position by examining first the Constitution and second Richardson and a wealth of corroborating authorities, but assuming arguendo, and arguendo, when you see it in an opinion, means for the sake of argument, essentially only for the sake of argument, but only for the sake of argument, while the evolving standards test for the Eighth Amendment may apply, we demonstrate that Section 241 still survives. So they go through the Constitution and they look specifically at the 14th Amendment. Section 2 of the 14th Amendment is the less familiar portion, but it reduces the number of representatives in Congress to which a state is entitled if that state disenfranchises any of its male, non-Indian citizens over age 21. And of course, now the male part would also, of course, include females because there is a later amendment that grants to women the right to vote. And essentially this was designed to ensure that male persons who were African Americans could vote in federal elections and in state elections. But there is a single exception. States may not be penalized for disenfranchising a citizen for participation in rebellion or other crime. The carve-out reflects a long tradition in this country and before that in British law and before that in the Western world. The tradition can be summed up in Lockean terms. If you break the law, you have forfeited the right to participate in making those laws. So in Richardson, discussed further in this case, the Supreme Court explained the relationship between Sections 1 and 2. The court's holding did not distinguish between the equal protection and due process components of Section 1, but rested on the demonstrably sound proposition that Section 1, in dealing with voting rights as it does, could not have meant to bar outright a form of disenfranchisement which was expressly exempted from the less drastic sanction of reduced representation which Section 2 imposed for other forms of disenfranchisement. None of the Section 1 provisions, according to Richardson, can be understood to bar what Section 2 plainly allows. Even if the Eighth Amendment were considered on its own terms, we are bound as interpreters of the Constitution to seek a fair construction of the whole instrument. This is you have to do it harmoniously. You have to harmonize different sections of constitutional and statutory provisions. They should be interpreted in a way that renders them compatible and not contradictory. And that's Antonin Scalia in his seminal book, The Interpretation of Legal Texts, sometimes hereinafter called Reading the Law. It's useless for the 14th Amendment to authorize felon disenfranchisement if the practice is made illegal by the 8th. The canon against surplusage warns against such unnatural readings. So we could go through this a lot further. The cruel and unusual punishments clause should not be understood to prohibit what the explicit language of the Constitution affirmatively acknowledges elsewhere as legitimate. It's Furman versus for Georgia. And in many of these cases, including one from 1996, it says that convicted felons may be denied the right to vote, and it's unexceptionable. Logically, Section 2 would not penalize states for disenfranchising a narrower group of those who were actually convicted of a serious crime. And that, of course, relates back to the wording of the amendment, which said participation in a rebellion or other crime. So theoretically, even if you just participated in a crime, even if you weren't convicted of the crime, you could be denied the right to vote. But obviously, that's not the way the law is interpreted. It's interpreted to apply only to people who are convicted of felonies. And they make note of the dissent. The dissent, echoing the plaintiffs, tries to elide this problem by asserting that only lifelong felon disenfranchisement after the completion of a person's criminal sentence is unconstitutionally cruel and unusual. But as will be explained, there's no logical stopping point for judicial repudiation of Section 2 felon disenfranchisement once judges wander into the subjective realm of independent judgment concerning the relative importance of the fundamental right of voting versus legitimate peniological goals of disenfranchisement. The dissent finds here no legitimate peniological goals foreshadows future rulings. Equally disturbing, the dissent's unprecedented extension of the evolving standards theory of the Eighth Amendment to this novel subject of post-conviction disabilities lays the groundwork for wholesale judicial revision of criminal punishments. And of course, that's the floodgates, that's the slippery slope argument that the court is making here. Now, the court goes on to note that they had already found in a previous case that Section 241 didn't evidence any discriminatory intent, and as a result, it's not barred in that way. And so, unsurprisingly, in the general text here, the court concludes that 241 doesn't violate the Eighth Amendment. But let's take a look quickly at the dissent. The dissent is authored by James L. Dennis, and it is joined by a number of other judges. It says the right to vote is the essence of a democratic society and preservative of all rights. Yet Article 12, Section 241 of the Mississippi Constitution of 1890 mandates permanent lifetime disenfranchisement of a person convicted of murder, rape, bribery, theft, arson, obtaining money or goods under false pretense, perjury, forgery, embezzlement, or bigamy. Disenfranchisement extends to free people who have completed all terms of their sentences. Plaintiffs argue permanent disenfranchisement of free persons who have completed all terms of their sentences constitutes cruel and unusual punishment in violation of the Eighth Amendment. Under well-settled principles of Eighth Amendment jurisprudence, the plaintiffs have met their burden. A national consensus to this effect has now formed among a large majority of the states. To dodge this conclusion, the majority largely conflates the plaintiff's challenge to the punishment at issue in this case, permanent disenfranchisement to free persons who have completed all terms of their sentences, with a challenge to felon disenfranchisement in general. So essentially what the court there is saying, what the dissent is saying there is that the court is viewing this incorrectly. Instead of viewing it as a lifetime ban for people who've already completed their sentences, and thus would be under no other restrictions as a result of their felony convictions, these people are denied the right to vote forever simply because they have this felony conviction. Now, again, it's not every felony that counts. Under the Constitution of Mississippi, it's only the ones listed. So if you have a felony bad check charge or a felony DUI charge, you're not disenfranchised. But if you have a felony forgery conviction, you are. And the dissent is essentially making the case that evolving standards of justice, evolving standards of jurisprudence should make way, and because other states have changed their laws to effect a re-enfranchisement, if you will, of certain felons, that Mississippi's statutes and constitution should be interpreted in the same way. But that's not how the courts work. The courts don't make policy decisions for the legislature and the people. Constitution is an organic document. It has to be essentially ratified by the people of the state, and they didn't ratify that policy choice. They ratified the policy choice from the 1890 Constitution. Now, certainly it's been a long time since 1890, and you could make a different decision if it were put to a vote today, but of course it's the legislature that drafts changes to the Constitution, and they haven't drafted one. And so the Fifth Circuit says, hey, if you want to change this, go back to the legislature. That's what I have for you today. Hopefully you found this interesting. Thank you so much for watching. If you have the opportunity today, do something nice for somebody. The other day, as I mentioned several days ago, you just let somebody go out in front of you in traffic, or if you've got a cart full of groceries and somebody only has a couple of things, you let them go in front of you. Just the little minimal things like that are kindnesses that you can bestow on people are such a great way to make somebody else's day better, and eventually they'll make the world a better place. Because kindness is never repaid. It's only passed on. After you've done that, come on back down here tomorrow, catch me down here at the beach, and we'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.